SJC-12312, Commonwealth v. Jonathan C. Pickering.
Ms. Carty, welcome back. Mr. Steinfeld, welcome back.
Thank you.
You may
Good morning. May it please the court, Emily Carty for Mr. Pickering. Mr. Pickering appeals from the revocation of his probation out of the Essex County Superior Court. And this case presents a couple of issues, and actually the parties agree that the judge erred here in excluding the evidence of Mr. Pickering's intent in the email exchange. But there is disagreement, obviously, in the degree of prejudice this caused Mr. Pickering and his defense, and also whether or not the psychotherapist privilege applies at all in the context of group therapy, which is perhaps a threshold question. My intention is to start with the prejudice question and then move on to the psychotherapist privilege.
Before you get there, can you answer one question for me? Do we have sufficient information in this record to answer the question about the group psychotherapist privilege?
Yes, Your Honor, we do.
Okay.
It was a topic of conversation throughout the two-day hearing.
Right, but was there anything introduced about that this actually was a person conducting the group therapy who was covered by the statute, or that anybody invoked it, things like that?
I didn't understand your question. Those are the two issues on which the Commonwealth concedes are whether or not Mr. Nazaro, who was the person who was conducting the group therapy session, qualified under the privilege. And there is nothing in the record to suggest that he was a psychotherapist under the statute. So no. So therefore, the privilege didn't apply and the judge erred. And then the other issue...
I'm confused. We don't know if he's a psychotherapist, right? So how do we answer the question if definitively? Well, I mean, we can answer it abstractly, but we can't answer it in this case, can we?
I think that we can answer it in, that is sort of the tricky piece of this, right? That the issue is going to arise again if this court remands this back for another hearing. If this court agrees with the parties that, yes, the judge erred, and also agrees with Mr. Pickering that this was highly prejudicial and he essentially denuded him of a defense, and therefore he's entitled to a new hearing, the question of whether the privilege applies is going to arise again and should be decided by this court. In conjunction with, whether or not the person who's conducting the privilege was a psychotherapist and
Let me just clarify. I just want to make sure I understand. So we don't know if he was or he wasn't, but we do know there was no privilege asserted here, and actually Mr. Deschaines, whatever his name is, actually breached the privilege himself, right? Because he's talking about what's going on here.
Right. If we assume that group therapy, that the privilege applies to group therapy, which is a common sense, I think, given the state of the law, that it probably would apply. Yes, when Mr. Deschaines testified about what Mr. Pickering said in group therapy, he breached that privilege. He burst the confidentiality bubble.
If there was one.
If there is one, and again, it's tricky, but it is a sort of a necessary issue to decide because it requires guidance from this court.
I'm sorry. How do we get to prejudice then? Isn't this just a remand? Because if the privilege doesn't apply because this person's not a qualified psychotherapist by the statute, then it wasn't. There was no error, right?
No, Your Honor, there was an error in then excluding the evidence of Mr. Pickering's intent. So right. the result of the privilege not applying here was...
I'm sorry, right.
That's fine.
Right.
It gets twisted.
This is sort of an unusual setting for this, but exactly. I gather that there is no dispute between you and Mr. Steinfeld that the privilege, if it exists, has to be invoked. Correct?
Yes.
and that the group therapy privilege to be, if anybody were to invoke it, it would be Mr. Duchesne, because it's his communications which are at issue,
That's right. Well, yes, yes.
and that he not only did not invoke it, but also spoke about what had occurred during the course of it.
That's right. And in the traditional application of the psychotherapist privilege, where there is one psychotherapist and a patient, that, yes,
So
that's the way
let's
the
go
law
to the
works.
issue of, let's assume that the judge erred, and that he should have been allowed to elicit what Mr. Duchesne would have learned during the course of that group therapy session, or what the defendant learned about Mr. Duchesne.
That's right.
Give me your best case as to what he would have learned that you say affects the fairness of the adjudication.
Well, what he would have learned is that, or what we believe that he heard in group therapy was that Mr. Duchesne was convicted of indecent assault and battery on a child under the age of 14 and enticement of a child in the context of a relationship with a child. And again, the Commonwealth's argument that the truth of whether or not this was a mistake or not a mistake doesn't actually matter. What matters is that Mr. Pickering knew this, and it matters how that would have affected his intent in engaging in an email conversation of the nature that he did with Mr. Duchesne. That gives you reason to believe, and the judge reason to believe, that he believed this was fantasy and not actually enticement of a child.
And it doesn't matter that he's in general in a sex offender group? It has to be more specific as to these specific allegations against or convictions on Duchesne?
Yes, Your Honor, because again, and this is in the record. It is in the record that not everyone in the therapy group were convicted of offenses against children. It could be other sexual offenses, and here the charge is enticed, or the allegation is, he was never really charged, but the allegation from the violation is having to do with enticement of a child. And so if there's any conceivable reason to believe that he believed that this was fantasy, he has to know that Mr. Duchesne, was convicted of indecent A and B on a child.
Yeah, so it should have come in. It's probative. It's probative as it relates to your client's state of mind.
That's right.
So, and I'm not even sure that the Commonwealth would disagree with that. Maybe they will, but it seems to me it's relevant and it's admissible.
Right.
So, going back to Chief Justice Ganson's question, so as you look at all the evidence that was presented, the exclusion of that evidence that should have been admitted, why is it prejudicial?
Sure. It was an essential piece of his defense. He has a right as a probationer in a violation hearing to present evidence, to present a defense, and included in that right is to present evidence that makes other evidence more credible. And this makes more credible his defense that he believed that this was an adult and that this was just fantasy. And it also supports and makes more credible the forensic evidence showing that Mr. Duchesne's name could have popped up on the emails rather than the sort of anonymized Craigslist name.
The difference between Mr. Duchesne's being a sex offender and being a sex offender based on kids makes it more likely that Mr. Duchesne's name popped up on the telephone?
No, Your Honor, sorry if I wasn't clear. No, Mr. Duchesne's conviction, or Mr. Pickering's knowledge of Mr. Duchesne's convictions of having sexual contact with a 13-year-old, coupled with the fact that you have evidence indicating that Mr. Pickering could have seen that it was Mr. Duchesne's emailing him, those two things together create the defense that he wasn't enticing a child, he was engaging in fantasy. And this is the import of this evidence is it's about persuasion. It's how persuasive is this defense. The judge wouldn't have had any reason to believe this without this evidence, and he didn't.
So I get that there was evidence forensically that he might have known that it was Mr. Duchesne,
Right.
but the defendant didn't testify here, did he?
No, he didn't.
So how was the defense that this was all fantasy play? What is the evidence that was before the judge that this was fantasy play if the defendant didn't testify and say, that's what I was doing?
Well, that's part of the problem, is that this evidence that was excluded would have enabled him to present that defense. The judge was on notice that that was the intended defense, and throughout the hearing, the defense attorney repeatedly says, but, you know, this is our defense, and in fact, before the hearing starts, this is her defense, this is what she presents to the court. And it's argued in closing that this is the defense. But the problem is that, yes, he wasn't permitted to put on the evidence.
And the cross-examination of Duchesne's suggests that that your client knew who he was, right?
Well, exactly, and the forensic evidence. The other piece of that is that he, I'm sorry, I lost my train of thought, but the defense was, throughout it was consistent that this was fantasy, and that the judge said was well aware of that, and was well aware that this evidence was important to that defense, because the judge says to the counsel a number of times, but he has to know that this information, he has to know about this information. It can't just be out in the world that Duchesne was convicted of these crimes. Mr. Pickering has to know about them in order for them to be relevant to your defense.
So I guess your argument, is that to try and use this defense just with Duchesne's name showing up on an email, especially when the defendant didn't testify, which is his absolute right, that's just not going to work. And to have a chance to marshal the evidence and suggest that a preponderance of the evidence wasn't satisfied, you needed this piece of information.
That's right. And the Commonwealth, going back to Justice Gantz, your question about him not testifying, he also wasn't permitted to get up onto the stand and said, this is what Duchesne said in group therapy. Originally, the judge said, well, you know, he can take the stand and say it. But then he backtracked on that in the second day of the hearing and said, no, he can't testify, and Duchesne can't testify to it. So, you know, there's no way for you to put on this evidence. And the attorney says, yeah, there's no way I can put on this evidence. My hands are tied. He has no defense. As to the Commonwealth, the strength of the Commonwealth's case, the Commonwealth argues that their case was strong because of this police report, and Justice Lowy, you had asked about all of the other evidence, and whether or not this was really prejudicial. The other evidence, the Commonwealth's case is only strong because this evidence of Mr. Pickering's intent was excluded, right? Of course, their evidence of intent looks strong. I mean,
Well, the police report's pretty strong, though, the prior incident.
But that was, of course, it's prior bad act evidence, which is always potent, and this is potent. However, that evidence was admitted for the limited purpose to rebut Mr. Pickering's defense, the evidence of which he was precluded from presenting. And so he doesn't get to present his defense, and the Commonwealth gets to present this highly potent prior bad act evidence. And so of course that looks strong in the face of not being able to present your defense.
Now, he was arrested at McDonald's, I gather.
Yes.
Is there any evidence as to what occurred at the time of the arrest?
I don't recall from the record whether
And how does his going to McDonald's fit into his fantasy play defense?
Oh, in terms of going to the site.
I guess purportedly, he was going to be meeting the boy at McDonald's, I believe.
He could have very well been meeting the person he was engaging in this fantasy with, who was a member of a sex offender therapy group. And if he knew that it was Deschênes and that they potentially shared these sort of interests and proclivities, and they were going to engage in whatever activities they were going to engage in, they could do that. The other thing is his Craigslist ad wasn't directed at children. The Craigslist ad that sort of initiated all of this was directed at and there was no age, and so he could have just been.
Didn't it say young or something like that?
There were no age. I don't know.
No
It's
numbers,
men.
but-
I think it said men.
Oh, okay, I thought there was a reference to
But
young.
But again, going to being arrested in a specific place doesn't actually hurt the prejudice argument, because he could have just been going to meet up with the person he thinks he's going to engage in this fantasy with.
Does it matter that he's also done something like this one time earlier?
The 2009 police report.
Yeah, I mean, it's just, he's gotten himself into serious trouble once before by, engaging in this kind of activity. And that doesn't satisfy the preponderance of the evidence standard for probation revocation?
I think what your Honor's pointing to is precisely the danger of prior bad act evidence, which is that it can lead us to consider someone's proclivity, right, and to be used for proclivity. And the judge here almost didn't allow that 2009 police report in evidence because he said it just smacks of proclivity evidence. And so I would just caution the court not to consider that he's done it once, and so therefore this is the same situation. There's evidence in this record that he knew that it was Scott Deschênes who was emailing him. There's evidence that he knew who Scott was, and there's evidence, and there should have been evidence to show that he could have believed that Scott would have been interested in this sort of fantasy.
So what was excluded from consideration wrongfully is the fact that he had the indecent assault and battery on a child and an enticement conviction.
And that Mr. Pickering would have known that, not just that.
That was voiced during.
Right, not that just that he is, the truth of those convictions doesn't actually matter.
Right, and the defendant knew about it.
Right, and Mr. Deschênes' explanation of the truth of that doesn't actually matter either. It's just sort of the effect on the listener. If you think about it in the hearsay context, why do we get to put this in? It's the effect on the listener, the sort of the intent, how it would have affected his intent, and it is his convictions, and also the fact that those convictions occurred within a relationship that Mr. Deschênes had with a 13-year-old boy.
Okay, thank you.
Thank you.
Mr. Steinfeld?
Good morning. May it please the court. Kenneth Steinfeld for the Commonwealth. The Commonwealth is asking this court not to decide the very, very, very important question of whether the psychotherapist patient privilege applies in circumstances like this in which you have court-ordered group sex offender, because it doesn't have to, and the record below is woefully inadequate for that to be determined in this case. I don't think that the privilege complicates matters. I think it simplifies them, because, as has been noticed, the Commonwealth agrees that the evidence should have been admitted because there was no invocation by Scott and no evidence as to the professional licenses of the person in charge of the group.
Mr. Before you get to the prejudice issue,
Sure.
if we were to decide the privilege issue, obviously there's no assertion of the privilege, so there is no privilege. We don't have to reach it. Putting aside qualifications of
That's correct.
just even putting
That's
that
correct,
aside.
even if there had been evidence.
Right. But this is difficult for trial judges, and Judge Feely was trying to do the right thing here. So when you're dealing with a spousal privilege, we expect the judge to let the witness know that he or she has a spousal privilege. Many judges, when there's an attorney-client privilege and the defendant's about to say something that's going to breach the attorney-client privilege, a judge might say something. So if this witness is about to breach the psychotherapist-patient privilege, and if we reach the issue, should the judge say something? Should we reach that issue? Should we talk about it in the opinion?
No, I don't think so at all. I think this court should limit itself to the question of prejudice.
But if we,
But there is no
But if we reach,
Right.
I appreciate that, and maybe that's what'll happen. But if we reach the issue of privilege, should we say something about sua sponte raising these issues like we have with the spousal privilege?
I don't believe that the law requires it yet, obviously, for the judge to tell a person who might have this particular privilege before he says anything that he may assert it or not. I think it is very, very clear the cases, especially Pelosi and Oliveira, that it absolutely requires an affirmative act by the patient. It says nothing about that decision necessarily being an informed decision. It's his job to do it. And he didn't do it in this case, obviously. And furthermore, there's every reason to believe here that he would not have asserted the privilege had he been told, you have a privilege not to say what you said in group. He had made clear by publicizing the whole exchange, by sending it to the group leader, he obviously had the defendant's best interest in heart. He was more than happy to share with the group leader what he had said in the exchange. And there's no reason to believe here. What happened here was just what happened in Oliveira, and that is the trial judge substituted his judgment for would Scott assert the privilege if asked, and he asserted it for him, and he cannot do that. In Pelosi, the court said that the Commonwealth cannot assert the social worker privilege, and it is clear that the judge himself cannot assert the privilege on Scott's behalf.
This is a little more complicated, though, because it's a group therapy, right? So the judge is intruding because Deschennes is originally violating Pickering's privilege. Right.
Respectfully, he is not. The defendant, Scott testified as to what the defendant said in group.
Right.
Right?
That's
that
a violation.
is not violating any privilege because the defendant did not assert his privilege. He permitted Scott so to testify. He did not object. So when Scott testified
he waived his, he didn't assert it.
Right.
So when he's sitting there silently, his counsel's sitting there silently, that's allowing Deschennes to tell what Pickering said in therapy.
Absolutely. He did not assert the privilege as you have to. So when Scott testified about what the defendant said, and I think this is very important, he didn't breach any violation because the defendant has an affirmative obligation to assert the privilege, and he didn't. So Scott could testify all day long about what the defendant says unless and until the defendant exercises the privilege, and he never did. So Scott did nothing
But the
wrong.
judge kind of jumps in. The judge on the first day of the hearing says, okay, and lets Deschennes talk about Pickering's actions. Then suddenly it dawns on them that there's potentially a privilege, and he stops, even though no one's asserted it. So it's like a one-way street a little bit, isn't it?
No, there's only, because the defendant did not assert his privilege. So Scott could testify, and he did so only very, very briefly.
But Scott didn't assert his privilege either, but the judge asserted it for him.
Right, therefore, the Commonwealth concedes that that was error, that Scott should have been permitted so to testify. But the fact that Scott testified about the defendant's statements, there's nothing wrong with that. The only testimony.
Could you turn to the? I want to make sure you.
Your Honor.
No, you're doing just the right thing. But I just want to make sure you get to the lack of prejudice.
Absolutely.
Because everyone's agreeing there's an error here, but it's kind of tricky on the prejudice point.
Absolutely. I don't think it's tricky, and I'm going to try to convince you why. At best, the defendant's proffer was that Scott would testify that he said at group exactly what he had said to Trooper Murphy. And what he said to Trooper Murphy was the following. When he was 18, Scott unknowingly had a relationship with a 13-year-old boy. He thought he was 16. Scott terminated the relationship immediately after learning the boy was 13. Scott pled to the lesser included of indecent assault and battery under. The whole thing was just a misunderstanding, and Scott had no interest in or involvement with underage children. That's the best possible testimony that the defendant could have expected from Scott.
But the point was that the defendant knew about that. I think that's what.
Right, I'm saying if he had known that,
Okay.
the leap from, okay, because I know that he pled guilty to this, but he says he's not interested in underage children, it was all a mistake, the leap from that to, therefore, I believed that Scott would initiate this exchange and would want to engage in fantasy role play, even though what he had been convicted of had nothing to do with fantasy. Why would you believe that somebody who had sex with a 13-year-old and then disclaimed any interest of it would have an interest in sexual role play? And not just sexual role play, but where Scott himself played the role of the child.
If he's telling the truth. I mean, what he says to the police officer may be different than what he's saying in therapy, where he may be forthcoming. Oh, I actually did want to have a relationship with that 13-year-old.
Right, but we don't know, because, and I think this is also very interesting, the defense counsel did not make a proffer at sidebar or anywhere that, according to my client, the defendant, Scott said this in group. He only said, Scott will testify, or she thought Scott will testify in court exactly to what he told Trooper Murphy. Now, there's no reason to believe that that's true, but even if he had testified to what he told Trooper Murphy, that would not have had the desired probative effect that the defendant says it has. And I want to point the court's attention to pages 8 and 9 of the second volume of the transcript, where Judge Feely essentially says what he would have thought of that evidence had it been admitted. He said, he called that evidence fairly speculative at best, that Pickering, having heard all of this and then acted in a certain way, and this is Judge Feely, and that seems like a huge jump, because even if he heard it, is it a fair inference that he, as you argue, that he acted as part of a fantasy role play? So clearly Judge Feely did not think that there was much probative value in that evidence, just a mere knowledge on the defendant's part that Scott had had sex with a 13-year-old.
Just
But
to
she-
back.
Oh,
Go
go
ahead. No.
I was just going to say, but the defense attorney didn't get a chance to argue it. So maybe it would have been persuasive to hear about how, in fact, this testimony or this information, receiving it in group, would actually make one believe that, in fact, I'm dealing with Duchesne.
Sure, but it's her burden to make a proffer of what the defendant would have said so that we can judge what the probative value of that would have been.
Even if it was just that information, being able to argue that was not available to the defense.
Yes, that's correct, but I'm saying that the probative value of that would have been so tiny, especially given the judge's own statements about how tenuous he thought that was. And
Just on their own statements, the statement before it was the judge going, is your client intending to take the stand and say exactly what he thought he was doing? Then defense counsel says, I don't believe so. Then he gets into, then it's fairly speculative, right?
no, it is testifying not to what he thought, but the question was, will he testify as to Scott's statements in group?
I know, but I think the judge is sort of saying, well, this is speculative because your client isn't going to testify, right? He doesn't.
No, I don't think he's making that connection. He believed mistakenly for the whole first day and most of the second that the defendant would be able to get up and testify as to Scott's statement, but he ultimately realized after defense counsel pointed out that that was probably not correct, and that's true.
What do you say to the defendant's argument that this is all he had? So you've got the case being put in by probation / the Commonwealth, and certainly no one would argue enough to find by a preponderance of the evidence. And then taking Justice Budd's point, now we've got closings, and you've got the Commonwealth's evidence, and the defendant gets up and he has to say, well, the name's in an email, and he can't even get out his defense.
Well, but the need is not enough, and the probative value of the evidence was so weak that he wasn't harmed by it. Ordinarily, the rules of privilege, rules of evidence, do not give way to the need of a defendant. He was not prohibited from introducing the defense. And the whole thing also depends on the belief that the defendant saw Scott's name in the exchange. Otherwise, there'd be no way for him to make any connection with Scott in group. And Judge Feely found permissibly, based on the record, I say implicitly, that he didn't credit the evidence that the defendant could see Scott's name.
That's why the corroboration might be even more important.
Right, the defendant could have testified, I saw his name on the chats. I'm sorry, the exchange, but he didn't. The defendant's own expert said, I cannot say with certainty what appeared to the defendant while he was engaged in the exchange. I don't know. And Scott testified about the procedures that he used to ensure that he could not be discovered by the defendant. He went way out of his way to make sure that the defendant would not know that it was Scott from group. And he did that by a bunch of different ways, both by having a phony email that he made up and also going through the Craigslist post where the privacy settings were on, so it masked the name and email of the original sender, but also by using very, very generic terms in his exchange. So there's no reasonable or no basis for a reasonable belief on the defendant's part that as soon as this chat started, when Scott says, very cute, talking about his picture, you say, oh, this is Scott from group. And even if it says Scott DeShane, there's no evidence that the defendant knew Scott's last name. The only evidence on that was that Scott signed the sign-in sheet with his full name. But there's no evidence that the defendant ever saw the signed-in sheet. So there's literally no evidence that he knew Scott's last name was DeShane. So even if Scott DeShane had come up, which the judge found permissibly that it did not, it's still a huge speculative leap that the defendant would have known, oh, this is Scott in group. Because he has been convicted of indecent assault and battery on a minor, he must be wanting now to engage in sexual role play as the child. My argument is that is very, very weak, very tenuous, very speculative, and as Judge Feely said, so had that testimony been adduced, if Scott had been permitted to testify what he told to Trooper Murphy, that it would not have advanced the defendant's case at all. That's especially true when the standard of review is by a preponderance of the evidence. And here there was, in fact, very, very strong evidence that he believed that he was talking to a 13-year-old. The fact that evidence is admitted for a limited purpose does not mean that it cannot be very, very, very powerful evidence of that limited purpose. And I think that was exactly the case here. The similarities, both of the 2009 incident in North Andover and here, the ads that he put are identical. They both do refer to young men, and in the ad here it said young men less than 25 years of age. But he had done the same thing in 2009, and yet he ended up going to meet a person he believed was a child, and he pled guilty to that. I just want to clarify.
Can you address the McDonald's point too? So what happens when he shows up? I can't remember.
That's in the prior case.
Okay,
that's in the 2009 incident.
Okay.
And that's just what I was going to say. In case there's any confusion, that has nothing to do with this case. That's just how he got caught in the first case. Here, he never traveled anywhere. He didn't do anything because they didn't set up an actual meeting. Scott just sent or forwarded the email to the court.
So if we don't agree and we think that the defendant should have the opportunity to present his defense, you still don't think we should decide the group therapy privilege?
Yes, that's correct. I think that the situation should arise. First of all, it comes to this court through a fairly bizarre path, and the incentives are switched. The defendant here wants the statement to be admitted. This issue, this very important issue, should be decided in a case in which the Commonwealth seeks to introduce statements by a defendant made in group. That's the quintessential how these privilege issues come. And then the defendant will file a motion to suppress or a motion in limine to exclude statements he made in group. And then there'll be a hearing, and the trial judge will take evidence, and there'll be evidence of whether or not there were contracts entered into. There'll be evidence of the status of the person in charge. There'll be psychiatric evidence about the dynamics of group therapy, none of which is present here. And then there'll be a decision. So this very important issue should be decided when it's presented squarely to the court like that, and not in these circumstances where this defendant's interest lies elsewhere. His interest is that there be no privilege in these circumstances, because ultimately he wants Scott to testify as to what Scott said in group.
Is it fair to say there's no proffer when the proffer itself would have revealed the so-called privileged communication, which the judge said cannot be heard?
Well, that's a difficult issue. They could have done it at sidebar or in camera.
Still a bench trial for the judge.
Yes, this is a bench. Well, it's a probation and revocation hearing anyway. But the defense here did make a proffer that Scott would have said in group what he told to Trooper Murphy. So, and no one objected to that. So there's a procedure where the judge could learn what the statement would be. And again, Scott never expressed any desire not to testify, and there's no reason to believe that he would have asserted the privilege had he been given the chance.
And when we deal with the issue of prejudice, is the fact that it's preponderance as opposed to proof beyond a reasonable doubt bear on that?
Absolutely. I cite an appeals court unpublished case, and I couldn't find anything else. But it seems to me that if that is the standard, that to create a reasonable doubt is different from switching by a preponderance to not a preponderance. Of course, we don't know whether Judge Feely found 51% or 97%, but presumably he had that entire range. So that case I cite says there's no substantial risk, especially in light of the fact that the standard is by a preponderance. And here, given what I think is a lot of evidence that the defendant intended to entice a 13-year-old boy and had no idea that he was talking with Scott, I think that shows definitively that there was not sufficient prejudice for this court to reverse the order finding him in violation of his probation.
And was there any evidence of the arrest here?
None. There is a docket entry that shows that in
No, at the hearing, not.
No.
The hearing made no reference to how he was apprehended.
Not at all. No, but he had been held for quite a while before, because there was a series of enlargements while the defense expert got to examine the defendant's phone, but there's no evidence of how he came to be in court.
All right, thank you.
Thank you very much, Your Honor.